my name is Samantha Johns,
My name's Will Gray.
My name is Jimmy Johnson.
and we are doing our legal and ethical group project presentation. So I'm going to start us off today with talking about issues concerning religion. And then Will will go, and then Jimmy will finish us up. So the first thing that we see with issues concerning religion are the Supreme Court case Reynolds versus United States. That was when the Supreme Court said that there should be a separation of church and state. So because we as schools are government agencies and personnel, we have to follow that just like everybody else does. So one of the tests that school administrators and teachers can use to make sure that we are not violating any religion is to follow the Lemon test. So it must have a secular purpose. So if you are going to teach something or have something posted that has a religious purpose, that is breaking that Lemon test and would therefore be violating religion, freedom of religion. It cannot advance or inhibit religion, and it cannot create excessive entanglement for the school or for you as an employee of the school. So there are a lot of issues concerning religion in schools. So I'm just going to focus on four today. The first thing being prayer. So this has been, quite a hot topic over the past several years. The Engel case was when this kind of started, is when prayer recitation in schools was seen as a violation of the First Amendment. And then we saw that in Jones versus Clear Creek Independent Schools, that as long as it is student-led and not encouraged or led by school personnel, it is good. It's not violating any freedom of religion. You also have to be careful that you're not sanctioning any kind of silent prayer or devotion time or anything like that, because that again would be breaking that Lemon test. Bible teaching. So you can teach the Bible in school, but it cannot be taught in a religious manner. It has to be strictly secular and taught objectively, and the Bible has to be seen as like a historical document or a philosophical document and not a religious document. As far as religious symbols and displays like in your classroom or on your person, like a shirt or something, you just want to make sure that it is not promoting or inhibiting any kind of religion, and make sure that like I know we've had an issue come up when we were doing our our projects and our different writings, that if a student has a cross or something on a religious display or like a poster, we can't take it down because there's a cross but leave something else up. But we just cannot be promoting any type of religion in our classrooms or from our t-shirts or our dress or anything like that. And then the last thing as far as religion is you cannot be fired or get an increase of salary or anything like that as far as employment due to religious discrimination. So if you as a teacher don't want to go to an assembly because it violates your religion, you can't be fired based on that. But we just need to make sure that we are following the Lemon test as educators and administrators. The next thing I'm going to talk about is freedom of expression. So we have freedom of speech, and we have to figure out how does that work in the school setting. So in the 1960s, the Tinker case came about when students were wearing black armbands in protest of the Vietnam War, and they were suspended for it. And so the Supreme Court case decided that their constitutional rights don't end at the schoolhouse door, that they do have freedom of speech rights. But there's some rules to that. So there can't be a substantial disruption. You can't have offensive speech, you can't violate the school rules, and you can't, of course, destroy school property or disregard authority in your teachers or administrators. But in that case, all they were doing was wearing the armbands. And so the suspension of those students was breaking their freedom of speech. Sometimes students want to wear buttons and pamphlets or insignias, and they can do that as long as the message is not vulgar, obscene, or mock others based on race, origin, color, sex, or religion. And students can protest, but they also have to follow 3 rules. And that is, it has to be peaceful, it cannot violate school rules, and it cannot result in destruction of school property. So as long as they are following in those 3 rules, students are completely able to practice their freedom of speech and protest and demonstrate something that they are not happy about or want to change. And the last thing I'm going to be talking about today is search and seizure. So I know that as a middle school teacher, I've seen a lot of this as far as vaping is concerned and having to search students. You have to be careful when you're searching their person and their things. The locker and the desk is school property, but their backpack and them are not. So you have to make sure you have reasonable suspicion to initiate a search. And that means that the information is considered reliable and the informant is known. So you know that teacher, you know that student, and they came up to you and said, such and such has blank, I saw it. I've had that happen in my classroom where I've seen a student pass something that was a vape that I saw was a vape, and I told my principal and he had to come do the search and seizure of that. So 2 Supreme Court cases that kind of help us as far as what to do in a school setting with search and seizures are New Jersey versus TLO. So searches are subject to standards of the Fourth Amendment, but warrants don't work in a school setting. So the only time, and I'll show you on the next slide, the only time that warrants have to be, used is if police are involved, because it just takes too much time when you are trying to get something off of a student that could be potentially harmful to them or others. AH versus State said that gut feelings don't support reasonable suspicion. So you can't ever, as a teacher or an administrator, go, well, I think they have this on them, or I think I know that he vapes, so I think I can search him. You have to have that reasonable suspicion. You have to have an informant and reliable information. Random suspicionless searches violate the Fourth Amendment and cannot be done. And the primary purpose that you want to make sure you're following is that you are securing evidence of student misconduct. We're not trying to catch kids doing stuff. We're trying to figure out this evidence that we have heard about. And you want to make sure that your searches are conducted in private. So like I said, law enforcement, when they become involved, you have to have a search warrant, and you also have to contact parents, and they can be there when the search is happening, as long as if the police officer is there. If you have to do a pat down search, you want to make sure that the school official is of the same sex and you have an adult witness to witness that pat down search. I know that I have never witnessed a pat down search. I know we typically just try to have the students kind of move their jeans or open up their backpacks or different things. Those pat down searches can get you in trouble a lot of times. Arbitrary searches or mass shakedowns cannot be justified as reasonable, and they are illegal. And then once you have a canine come on, the only reason for a canine to come in is that if there's imminent threat to student safety. So if you have heard wind of, something like a bomb or a weapon or something like that, that is when canine searches need to be used. All right.
All right, so Samantha just told us about search and seizure and how the invasiveness of the search needs to match the specificity of the evidence. Due process is what I'm about to talk about, and it's not a whole lot different as far as matching steps that you take with the consequences that'll happen in the future. So the first thing that we have to consider is the staff member tenured or not? Okay, and if they are tenured, it's a different set of steps that you're going to have to take. That is full due process that's been vetted throughout both state and federal courts, because there's property rights to the position, and that's the biggest single difference between the tenured due process and the non-tenured due process. Things that you would want to do as an administrator for one of your staff members would be prior notice of intent. You also have to communicate the grounds. What's the nature of the violation? You've also got to create, basically it's almost like a due process plan where it outlines goals, steps to be taken, timeline, and then the outcome, almost that you would like a lesson plan with the intermediate steps that are there. It also allows a tenured faculty member to be able to appeal the decision, whatever that might be. That appeal would obviously be outside of the individual school, most likely to the HR or to the deputy superintendent. So on the next slide, we've got non-tenured teachers. And so in this situation, these are jobs that are put out there normally in the first 3 years of teaching in a new school district, that the contract is fixed in. So there is actually an end date for the contract, normally the last day of school in May. During the contract, so let's say between the starting date in August and the ending date in May, due process is required. If there is something egregious enough that would require a mid-year firing, due process is required. However, if it's something like incompetence, most principals are just going to allow the contract to expire, because at that point, the fixed period contract is over. You do not have to follow due process, and it can be non-renewed for any reason, any at all, as whether it's petty or it's something more significant. However, there are a couple of statutes that have to be stepped through. The first one would be written notice. That's normally, I think it's the last Wednesday of school in May. All of the envelopes get handed out normally by the administrator for those teachers that are being non-renewed. And so that's the big difference there. And what you end up seeing is unless there's a truly egregious offense, most principals are just going to wait till the contract is up. On the next slide, we have a short case study. Due process law is evidently something you can specialize in because there are so many nuances to it. Several that are relevant either to the state of Alabama or to the way that sort of the broad strokes associated with due process is that the first one was with the state of Alabama. It had a retired employee decide to come back to teaching after a period of time, and I believe it was less than a year. And the Court of Civil Appeals in Alabama said that tenure was lost once that associate or that employee entered retirement. The second one was at the federal level in the Fifth Circuit Appeals Court. And what it determined was the principal can only recommend the firing or the hiring, but until the Board of Education approves it, it is not official. So that's an important step. A lot of times that process starts for hiring and firing as early as February, but until the actual board picks that recommendation up, it's not in stone yet. You've also got that there's no in the Roth and the Board of Regents of State Colleges, and I believe that's in New Jersey off the top of my head. There's no reason for the non-renewal. When the contract has a fixed date to expire, there is not a reason to have to give a reason to the teacher for non-renewal. And then last but not least is the one that the Cleveland Board of Education versus Loudermill is where under the U.S. Constitution, it says that a tenured teacher must be notified through the due process procedures. And that was an important sort of high watermark that yes, tenured teachers do go through extra steps. The next slide is a couple of others, but this time it's specific with the most likely reasons an administrator would want to terminate or non-renew a teacher. And the first one is incompetency. This went through the state of Missouri courts. And it just established that tenured teachers need that process of an improvement plan, which was basically you just lay out steps, dates, other things that needed to get to the point. And if they still can't meet the goals and the steps that are provided in the improvement plan, then that is actually due process has been fulfilled and you can go further with termination. One of the things that's important in this incompetency, if an administrator chooses to use incompetency as their reasoning for the due process, the teaching certificate establishes the initial competency. So it's now on the Board of Education to show that teaching certificate is no longer, it's not enforced, but it's the steps the teacher is taking is no longer consistent with that initial competency. The next one is insubordination. And this is actually many cases. There's probably more than 10 or 15, maybe even more than that out there on insubordination in various industries. But there's a couple of things, and there's one thing that is almost universally will undermine an insubordination termination cause, and that is the directive, whatever it is, must be adequately and clearly communicated. So your principal, deputy superintendent, the assistant principal, whoever it is giving out instructions needs to do this in a way. Many times email is the best way to do that. That seemed to be a very sort of foundational way to do that because your school email is a lifeline, and that is through regular process of the day that employees check their email. And then the last one is is there's got to be a pattern of failure associated with that directive. Many times it's daily tasks, and you've got to look at it, what's going on across the school and then across the district. And if similar things are going on and the steps that the teacher is taking is just average, maybe not exceeding expectations, but meeting expectations, that's not enough by itself to become an exception to the rule. That's not enough to be insubordination. The only other thing that I saw was that and it was actually in one of our case studies that we did in class, but it had to do with, was the directive reasonable? Sometimes these directives just aren't reasonable. It's just not within the normal task. And that would be another way that you could use the insubordination rule. And so the next slide is now we're changing from due process to liability and the way that schools handle records. Now, this isn't a whole lot different because you've still got some processes here and some steps that have to be taken that's very similar to the due process case law. In this case, FERPA passed in 1974, and it really codified, at least explicitly, how records that are kept by schools and universities around the country are to be held. The year 2002 was a big year for this. We had two things happen, and it's not to be missed that 2002 was about the time that most colleges and universities and even high schools began relying on the internet for the first time. And so you started to see some of these cases percolate through the system, and these are the two that continue to pop up. In the Sixth Court, disciplinary records were actually considered academic or at least educational in nature, so they were maintained. And a good overall rule that I'll get to on the next slide or two will also apply in this situation. The other one was the Supreme Court of the United States. Peer-to-peer grading was not a violation of FERPA, and that's because the individual grade seen on the paper would not necessarily show up on a transcript in a permanent situation. So it was just considered sort of a passing transient type grade that did not really affect the long-term aspects of the student. On the next slide, we've got the coverages. So this is a big important part of this because we've got a lot of material in a school and so many different pieces of paper and a lot of moving wheels going on here. Most of the things that are included, I think transcripts, disciplinary, a lot of these are very vague files. What does files mean? So anything demographic in nature, a lot of times what happens, and this is where sometimes FERPA moves up to a certain point. My lights are on a timer, I apologize. And so the things that are not included are almost as important because in that very last bullet point, medical records. I know with my kids, I've got kids that are everything from asthma to type 1 diabetes and any other things. But once they turn 18, FERPA is no longer what governs those medical records. It is now HIPAA. And so despite the fact that FERPA doesn't cover that, it is still covered. It's just under a different statute. And the next slide is a parent's rights. So we've got a couple of things here. And the first thing is the inspect and review. I think that's where it seemed as if many administrators didn't understand that. They would almost put up a roadblock to access certain records. And so that's an important thing that the administrator needs to understand is that with very little pomp and circumstance, those records should be able to be accessed by the parents. If there's any errors, a parent has a right to at least appeal it. And then the last thing is that you can go to the Board of Education and even as far as the Federal Department of Education if things aren't changed like you would like. Other things the Board of Education needs to do, the procedures I believe are actually for our county, for Jefferson County, posted on the website for the main Jefferson County website, not just Corner High School. as well as the rights to notify the parents that they can amend. Legitimate educational interest as well constitute, and what constitute a school official. So that one to me is sort of the overarching idea with FERPA is if a student's actions can change the record, and then that record is kept at least semester over semester and possibly even year over year, then FERPA is likely something that needs to be enforced in this situation. And then last but not least, you have if a student is disabled, but they're not immediately qualified as disabled, that is something under FERPA that can be, the parents can be notified of that. And then of course, if a student or family is, English is not their primary language, they have a right to have all of this information communicated to them in whatever language is their primary language.
All right, I'll be following Samantha and Will with the individuals with disabilities and the code of ethics. Based on the findings, Congress determined that it was the best interest of the federal government to intervene and collaborate with the states in addressing the needs of disabled children across the country. This intervention was known as the EAHCA, which has been amended several times since it started. It was known as the Individuals with Disabilities Education Act in 1990, which was amended in 2004 and renamed the Individuals with Disability Education Improvement Act. Although the acts have been amended several times, the purpose and the primary goal has remained the same. Next slide. The number of children with disabilities has steadily increased. This upward trend emphasizes the importance on how we need to improve services to meet children's needs and ensure that they are getting equal access to their education. All right, next slide. The Alabama Educator Code of Ethics. I will be talking about 9 teacher code of ethics. The first one would be personal conduct. Teachers should adhere to generally accepted professional standards. Most schools' professionalism include, but is not limited to encouraging, supporting, respecting, and encouraging with fellow educators and collaborating for continued improvement. The next one is trustworthy, integrity, honesty. As educators, we demonstrate honesty and integrity through professional practices while advocating for the fair and unbiased opportunities for all of our children. Next slide. Third, unlawful behavior. Teachers must follow federal, state, and local laws at all times. Unlawful behavior includes, but is not limited to, conviction of a felony or any moral crimes. Unlawful behavior includes a guilty verdict, even if an appeal has been filed. Next, the relationship between teacher and student. All right, educators must maintain a professional relationship with all students inside and outside the classroom. The goal of a teacher is to create, support, and maintain a challenging learning environment for all students. One of our most important roles is to be trusted confidant for our students, a mentor, advocate for their growth. Next slide. Fifth, the use or possession of alcohol, drugs, or tobacco. During professional practice, all educators should refrain from the use of alcohol and tobacco products. Educators should never use illegal or unauthorized drugs for any reason at any time. Sixth is public funds and property. An educator entrusted with public funds and property should uphold that they trust with the honesty and accuracy of their responsibilities. Teachers who are responsible for a club or a sport accepts any kind of payment, participation fees, uniform fees, any kind of fees that they accept need to make sure that they keep up to date and accurate receipts. Next slide. Seventh is personal gain. An educator should maintain integrity with students, colleagues, parents, patrons, businesses when accepting any kind of gifts of gratitude, favor, or additional compensation. What that means is we got to make sure we uphold the institutional privileges and make sure that we're not doing anything for personal gain. Everything should be in the interest of the best interest of the school. 8 is confidentiality. Like Will stated, educators must follow all the states and federal, local, and school board policies regarding the confidentiality of students' personal records. Make sure that we keep any agreements or anything that we have confidential and not really sharing them with anyone. And then finally, next slide is contract abandonment. For the length of the contract, educators must fulfill all of the terms and obligations outlined in the contract. Abandoning the contract for professional services without the employer's prior release from the contract or refusing to perform services required by the contract are examples of contract abandonment. This concludes our briefing, and we have attached our references for your use, and thank you.